Hello, everyone. Welcome and thank you for joining us today. My name is Simone and I'm in the marketing team at OUP. And I'm delighted to be here with our guest speakers. And now, without further ado, I'm going to hand it over to Professor Irene Calboli so she can do the introductions and start the discussions. And I'm going to disappear behind the scenes. Irene, over to you.
So thank you, Simone. Thank you, OUP, for organizing this important meeting. It's very interesting for myself and my co-panelists, the speakers, to be addressing not, we often address lawyers' audiences. So this time we have a bit more an interdisciplinary audience, and we are especially honored by that. OUP is a publisher. We work closely with OUP, and so that's, again, another reason for being very honored to be here with you today and talk about artificial intelligence and how artificial intelligence interacts, or what are the many pending questions about the interaction with artificial intelligence in the creative industry, specifically in publishing. Not just, again, in publishing books, but in creating output based on a variety of discussions that are happening today. We are still in highly uncharted territory. This is a new technology, maybe not that new anymore, but still relatively new, that evolves at a very fast pace. Is a technology that we all talk about, maybe not too many of us really understand its potential, understand its functioning. But in the legal world, in the world of creative industries, the notion of artificial intelligence has really is really posing a lot of challenges about what's an author, who is an author, what's protectable. It's computer-generated material, AI-generated material authorship, and or is protectable. What about AI-assisted material? What about training of AI? What about AI implication beyond authors and copyright into the world of design, into the world of trade secrets, technology, development, and so on? And so we are very fortunate to have with us today two esteemed experts, Professor Noam Shemtov from Queen Mary University, the Center for Commercial Law Study, and the Intellectual Property Institute. I am an alumna of that institute, so I'm particularly happy to have any type of interaction with Queen Mary. And also, we are delighted to have, Oliver Fairhurst with us. Is also academic, but its main focus is private practice. So I would like to ask Noam to start the discussion first by introducing himself, and then really to focus on the question that it's probably the most interesting at this stage to open this, to open the stage and to break the ice with the audience. Can AI be an inventors, or is there an essential human component of inventorship? This is something that it's debated in ethics, philosophy, in court, in legal discussion, and so it's really a question that is transcending fields at this stage. And if AI could be an author, what could be its specific identification point for it to be considered under the current system, or maybe a new design system, the author of the future? So Noam, please, if you could start by introducing yourself and then address this very big question: AI, so the author in the machine, can the machine be an author or not?
Okay, thank you. Thank you, Irene. And thank you to OUP for organizing this, what I'm pretty sure will be a stimulating discussion. So as Professor Calboli introduced me. My name is Noam Shemtov. I'm a professor for intellectual property and technology law and the director of Queen Mary Intellectual Property Research Institute, so part of the Center for Commercial Law at Queen Mary University of London. And I've been working in these areas, so the intersection of law and technology, specifically in relation to intellectual property and software-based products or services in the broadest sense for more than a few years now. Now, when it comes to AI, I've been working in the area for a good few years, and actually some of the work that I have done, I would mention here in relation to Irene's first question, and that's a study that I have conducted a good few years ago for the European Patent Office. So if I start getting or straight to the heart of the question, to what extent AI can be considered as an inventor, I think this is a moot point to a large extent at the point in which we are now. So for a good few years, we had various iterations of what I would refer to broadly as the Dabus litigation in various places around the world. So Dabus was the name of those of us who are less familiar with the name. Is a name of an artificial intelligence machine or system that was created by a US inventor, Stephen Thaler. And what Thaler and a number of associates have done that was to file patent applications in various jurisdictions around the world where they designated the AI, namely Dabus, as the inventor. Now, patent law includes an obligation upon every applicant to designate the inventor. What they did is, rather than designating a human inventor, they designated the AI a system, which they named Dabus. Now, to me at least, unsurprisingly, those applications failed everywhere in the world. To the best of my knowledge, the only place, and maybe someone in the audience can correct me on that, the only place where this is still pending to an extent is an appeal, I think, before the Brazilian Supreme Court. Perhaps there is another jurisdiction out there, but my Brazilian colleagues inform me that they would be very, very surprised if that would succeed in Brazil. So let's put that aside for a moment and continue on the basis of patent law not permitting AI systems to be regarded or considered as an inventor. Now, if that is a settled point, and it is a settled point, as I said, to most intents and purposes, US, Australia, Europe, the EPO, Germany, the UK, and various other court systems around the world on both at patent offices and on appeals that has been settled, then if that is the case, then we must have a human inventor. But that gives rise to the following question. If an AI system cannot be designated as an inventor, and if it must be a human, which is to be designated as an inventor, in qualitative terms, what does a human need to do in order to do enough so that he or she may be regarded as an inventor? And here we don't have a uniform answer. And I think for our purposes and if I try to, and I will not try, but I will be brief, I will just point to two jurisdictions where this question was actually considered rather recently, so in the last couple of years. The first one is the United States. Now, the United States had what was thought to be the relevant test for inventorship was known as the intellectual domination test. This is actually a test that I have referred to in the study that I carried out for the European Patent Office. According to this test, as long as you have a human that was intellectually dominant over the process in question, you have your human inventor. And again, I'm simplifying it, but that's essentially what you needed to show. The USPTO in the last couple of years came up with guidance or guidelines in relation to AI, AI-assisted inventions and the role of the human within this process, and made it quite clear that, first of all, the intellectual domination test should not be referred to anymore, and what is needed is significant contribution. Now, they gave various indicators and pointers as to where and how one may actually identify a significant contribution. But what I think is the one that I would pick as problematic in to my mind is that if you do have a human that engages with an AI with an AI system on an intellectual level, that is not necessarily sufficient. So in my study, my view was that across jurisdictions, if you have a human agent, even before we had an AI, that stumbles upon an inventive concept due to pure dumb luck, he or she would still be considered as an inventor as long as they recognize the significance and utility of that concept. The guidelines of the USPTO suggest that that is not the case. What they would like to see is that this type of engagement go over and above what would be apparent to the skilled person. So, to my mind, this is well, not a mistake, but this is undesirable, because what they have done here, they basically conflated the requirement or the type of assessment that we carry out for the purpose of inventive step with an inventorship test. And I think this is likely to lead to problems and to a lot of to invalidity challenges at the point when you're trying to enforce specific patents, especially in AI intensive sectors. And if I compare and contrast that with the German recent decision from June 2024, I think the Germans, by and large, got it right. Under the recent, or rather recent, German decision, the Federal Court of Justice, the German Federal Court of Justice, referred to a natural person who significantly influenced the AI system. In other words, as long as you have a person that engages not on a financial level or administrative level, right, but in an intellectual level with an AI system and oversees an AI system in the course or on the path for creating an invention or coming up with an invention, that may be sufficient. They actually they referred, among other things, in that judgment to my study, where I also maintained that at the present state of play, we always going to have a human that does enough in order to be considered, and should have a human that does enough in order to be considered as an inventor. But I think that this is the next, I won't call it battleground, but this is the next key questions that patent offices and courts around the world would find themselves confronting. What does a human need to do in order to be considered an inventor under the domestic laws? And sometimes that would require a substantive decision, as in Germany or in the US. But alternatively, sometimes that may be determined by, let's say, procedural arrangements. For example, in the United Kingdom, by and large, a person that can challenge a designation of inventorship is a competing inventor. Now, if you think about an AI related scenario, it is hard to think how and who anyone can actually challenge my designated as an inventor if a person believes that it was not me, but rather an AI that did whatever it is that needs to be done in order to be considered as an inventor. So sometimes procedurally, it may be tricky to challenge a designation of inventorship, and the patent office itself is not likely to go into that. In the UK, I think this is also going to be, to a large extent, a non-issue due to those procedural arrangements. But I think I exceeded my time a little bit, Irene, so I'll hand it back to you. Thanks.
So thank you very much, Noam. And I would like now to ask Oliver if you can briefly introduce yourself, and maybe you can pick up on this question and you could extend on AI as not only a creator but also a designer. And the even in a country like the United Kingdom now, we have almost 100% overlap between protection for copyright and protection for design. Interestingly, we have not that much discussion about design in the AI space, but that's certainly something that's relevant. Trademark as well is something that it's less addressed in terms of problems with authorship or inventorship, but still that's something that it's important for our audience to be more aware of. So I understand that specifically in the United Kingdom, there are consultation going on design generated creation with AI. And there have been consultation on copyright and patent. And so now we are really seeing the legislators and the IP offices going full circle also with the other IP rights. So if you could develop a bit on this area, it would be great.
Thank you. Sorry if I'm a bit croaky. I've got this bug that's going around at the moment. Yeah, so I'm a partner at Lewis Silkin. I'm also a guest cat on the IP cat team. And have covered a lot of the AI litigation, particularly the Getty Images and Stable Diffusion case that went to trial this summer, and the judgment was handed down. Was it last month? Or the month before now? I can't remember. Yeah, so I mean, as with most things legal, the industry is far ahead of the law. It's far ahead of courts. It's far ahead of legislation. And all regulation as well. And AI is being used a lot in inventing things, in designing things, and in just generally in creating things. And the ability of designers, particularly product designers, to use AI to create new products is potentially transformative. So products can be created more quickly. There can be more variations to them. They can be better suited to users. If you take an example of someone who might have mobility issues, they could be a product could be designed for them that is much more suited to them, much more effective, much more easy to use, potentially safer. So there are huge advantages to the ability of AI tools to create products that are quickly designed and could potentially be protectable. There's even some, although I understand it's contested research, that products, particularly safety devices, so airbags and things, and car seats and things, are more appropriately designed for men. And even within men, there's a subset of men that they are predominantly designed for. It's a sort of average. And that can mean that women can be less protected or more at risk if they're involved in, say, a car accident than a man might be. So data-driven design that really takes into account different users could be really, really effective, could be really, really very good, and done in a way that humans just can't do. They can't create that much, those many different variations of things. And you combine it with new manufacturing techniques like 3D printing, you can see a real advantage to AI generated designs. Now, in terms of protection for those, so putting aside patents, for a moment, which obviously Noam covered. So other than in UK unregistered design rights, which is a specific UK design right that doesn't apply in that many other jurisdictions and is separate from the community or the EU design right, the authorship of the design is, and the same with trademarks, is not really that relevant. So there's no requirement for most designs to be human generated, to be original. Now, there's some UK case law that says for the UK unregistered design right, which the design must be original, and it's always been understood that that is the same originality test as with copyright. That was confirmed in a recent High Court decision. So if UK unregistered design right requires a design to be original in the copyright sense, that raises a big challenge if it's AI generated. But for registered designs and for what were in the UK community unregistered designs and are now supplementary unregistered designs, or EU unregistered designs in the EU and registered designs, there's nothing to stop an AI tool from being used in order to create those. It doesn't depend on a human author for subsistence. So AI can be an author in that sense. The same with trademarks. Trademarks, it doesn't really matter where it's come from. The point is it a sign that is able to distinguish the origin of the product or the service? Now, if it is, it doesn't matter if it was AI generated. So if an AI tool was used to generate a logo, that's fine as long as it's there. Now there is as long as it's registered, there is still the risk that someone might claim that it's an infringement of their copyright, and that can be a ground for invalidity. But there's no rule that says that AI can't be used to create it. Now, in my view, in both of those situations, that's quite a good thing. I don't see any reason why AI created trademarks or AI created designs should not be protectable. They can be the result of huge investment. They can be very useful to consumers, and they can be valuable. So I don't think there should be some carve out for AI generated tools. Now, there's a consultation, as Irene mentioned, in the UK on design rights that was proposing to exclude from some design right protection where the design was created by AI. Now, it was a bit unclear. It wasn't the best written document in the world. It was a bit unclear whether they were saying that could be to all design rights and not just UK unregistered design. Now, if that were the case and there was some general carve out, I think that would be very bad. I think that would undermine industry and undermine consumer rights and consumer welfare. But which I put in a response on behalf of my firm, saying exactly that point. Having said that, I can see some problems with AI generated designs. Now, as most of you will, I imagine, know, to be registrable design at the date of filing or the date of filing, it needs to be a new design, save for exceptions like the grace period, which is okay, and that should be fine. But AI tools can generate so many designs. You can imagine there be some kind of publicly available platform of every possible design of, say, a lamp, and there may be no sort of intention to ever create that product. But if that product were available on a large database, it would raise some issues, potentially not terminal ones, but it would raise issues as to the registrability of someone who created it entirely independently and actually did manage to and intend to market it. So I do think there are some challenges for the design right, but I think they're pretty navigable. So my view was that, as a general view, is that we should allow AI tools to attract IP rights the design right seems like a good one for it, where it doesn't give a huge and everlasting right, unlike copyright, but it does still incentivize the investment in the design that uses it. Irene, shall I go on to trade secrets now, or did you have anything to ask about that?
Perhaps we could move back to Noam. Let's keep it moving. I think that's important. So now we look at the copyright. We look at design, and if you can react, Noam, to what Oliver just said, adding some perhaps more consideration that can go again between you. I remember, our audience, it's focusing a lot also on the publishing industry. In the publishing industry, there is copyright, there is trade secret, there is design. So, maybe some reaction, and then we move back to trade secret to Oliver.
Okay, so Oliver, the risk of coming across is boring. I by and large, I agree with Oliver's point and Oliver's sentiment. I think that when it comes to so Oliver focused specifically on trademarks and designs, and I think that when in the case of trademark, any question that has to do with authorship, to my mind, is irrelevant. I just don't see the relevant. Also, when I look at the basics of the right and the underlying rational system for having trademarks and for protecting trademarks, I don't see how authorship should make a difference. I take also Oliver's point on when it comes to design on the issues that designs generated by AI can give rise to. So, for example, developing a huge corpus of designs that nobody uses, but they are there as potential blockers for novelty, in terms of novelty. But that, of course, would be relevant whether the new design, which is being assessed, is created by a human or by an AI. So this corpus, this potential corpus that may be disruptive would be or may be an issue, regardless of who is the author of the fresh design that we are assessing at present. When it comes to copyright, so Irene, you mentioned copyright. Would you like me to go into some copyright issues now, or I think that to me at least, and I'm coming here on the back of an event that I took part in just a couple of days ago with the publishing industry. So just over 40 publishers from the UK and beyond. Who, as you can imagine, very interested on the training side of things, where I think there is we have an intricate international picture as to the kind of jurisprudence that arises in various countries, and I think that this is really becoming interesting. So, for example, in the United States, what do we have now? Close to over 60 lawsuits in various types and colors and shades. I think that in the US, I will just focus. I think it's interesting. Focus on two recent decisions that got quite a lot of coverage in the news. Both of them hailing from actually the same jurisdiction within the US. So that's a federal district court in San Francisco. I think they were delivered just a couple of days, one after the other. The first was the Anthropic decision, and the other was the Meta decision. And there were various differences between those two decisions, even though in both cases, the court found in favor of the AI developer, whether it's Anthropic or Meta, and found fair use in both cases. I mean, in the case of Anthropic, of course, there was an issue of pirate libraries, and in that sense, there was no fair use. But what I found interesting personally is the court assessed fair use, or made this fair use assessment, and looked particularly at the fourth fair use factor. There was a difference, a clear difference between the two judges. So the earlier judge, at the earlier decision, earlier by just 2 or 3 days, the Anthropic decision, it was Judge William Alsop. He found that there could be, so the fourth factor, just as a reminder, the fourth fair use factor is the type of effect that the contested use has on the market. And in that case, the court found that there was no adverse effect, and more specifically, the court explained that the training data does not compete in the marketplace with the author's in the same market as the author's original work. And the fact that authors complain that by training an AI system that can then produces work that compete with theirs, they are basically making a similar complaint as though they would argue that training school children to write well may result in a potential future explosion in the marketplace of competing works, and therefore the court could not see any acceptable adverse effect under the fourth factor of fair use. If we move on just 3 days later, the meta decision, there the court took a completely, although the outcome was still the same, the court took a very, very different approach. Actually, the court rejected the reasoning in Anthropic and showed a willingness, if evidence is produced to it, if suitable evidence is produced, to actually accept what they call indirect competition. In other words, where you have an AI system that ingests a large number of works and then can churn out works that compete with the original works that were used as datasets, as part of datasets, and compete with them in the marketplace, thus saturating the market. In that way, that could be considered as a harmful effect under the fourth factor. The only problem in that particular case, the court made it very clear that although they invited the attorney or the counsel for the plaintiff to produce such evidence, no such evidence, not at least not in a convincing way, according to the court, was actually produced. So I think this is very interesting. It would be very interesting to look at, and if courts in the United States would show willingness to accept damage or harm under the fourth factor in relation to indirect competition and future saturation of the market, we may see a situation where AI developers and AI companies would be more inclined to sit at the table and reach licensing arrangements with content owners of copyright in content that is being used to train AI systems. But I think maybe closer to home, what is very interesting is first the case that Oliver mentioned. So that's the Getty images, and to contrast that case with the slightly more recent decision hailing from Munich, and that's the Gemma decision. And again, in here we see different approaches. And here I think, and I have I won't say a vested interest, but I have a particular interest, and I'll explain why. And here at the Getty, leaving training aside, the Getty images decision, one of the arguments that was put forward but was not argued to my mind at least, in sufficient detail, was that post-training, after a model has been trained, the model as trained may contain a copy or copies of the training data. Now, the judge in the Getty Images decision dismissed that argument, again, to my mind at least, while not analyzing this argument in sufficient detail. The German court here actually did that and was prepared to consider to what extent the weights or the statistical data, let's call it like this, the statistical data, the tokens that are that reside within an AI model could be considered as a copy. And the court said something which a paper not from this September, but from previous September, that I published with a number of colleagues, so Daniel Gervais, Professor Gervais, and a couple of other colleagues from the States. I actually argued in this, then speculatively, before there was any court decision to that effect, that a model as trained could be considered as, or may be considered as, containing copies of the work, because in the end of the day, a copy is not a term for our purposes of computer science, but it's a legal concept. And when I capture certain information from a work, statistical data, I hold it, I record it, I register it, and that enables me later to recreate the original, either in full or at least in a version that would constitute a copyright infringing version. As far as the law is concerned, there is a strong argument here that what we have is actually a copy in the legal sense. If I have a work which is represented, irrespective of how I call or how how I may regard that kind of information. It doesn't matter that a human cannot understand it, for example. I capture information that enables me to work it backwards to the original. That information may be regarded as a copy. And this is what the German court essentially was willing to hold. Now, again, if this kind of rationale would prove convincing to other courts, that means that Europe's Article 3 and Article 4 exclusions under the AI Act become much less relevant, because Article 3 and Article 4 do not touch upon post-training scenarios. Definitely not when you make those models available to the public post-training. So I think my last point is, watch this space. A lot of interesting things are happening in terms of the jurisprudence that emerges now across Europe and in the United States. In Germany, for example, this is of course now on appeal, so it would be interesting to see what would be the decision on appeal. But we live in interesting times.
Thank you very much, Noam. Yes, very interesting. I don't know if any of your publication was part of the settlement. In the US, we have been checking who have been, part of the settlement, and there've been even, funny posts such as, obviously, Oxford University Press is very much attend to these issues. I know there've been considerable discussion about which books were used and how now all this information are actually quite disclosed and public through specific searches. But let's go back to trade secret and Oliver. So we don't tend to associate, at least the average AI user or AI discussion, trade secret to AI policies, but in fact, trade secret is absolutely crucial, in terms of data protection, data access, and even the technology that it's evolving more and more, again, faster and faster. And so by the time a patent is issued, is obsolete. So, as in many other fast-paced fields, trade secret becomes, a very convenient alternative. So, do you mind in elaborating a bit on the trade secret potential discussion on artificial intelligence?
Yes, absolutely. Although I just first, just to come back to, I don't want to make it all about Getty and stability, but just a couple of quick points. One is that the whether or not the model weights contained a copy of the original underlying works was accepted in the case as that Getty accepted that it didn't, which meant that the judge wasn't really able to make the finding. Whereas I think, if something is able to reproduce it on demand, reproduce something on demand, that absolutely it must contain it in it. Otherwise, it wouldn't. I can look at a computer. I don't really understand how it's generating images on my screen. It doesn't really matter if it's got copies of it. It's got copies of it. So I think there is an issue with that. The other really important thing, which I think for publishers is going to be very important, is that Stable Diffusion or Stability AI was found liable for trademark infringement. And now it was only for some of the earlier models. But if you look at how most AI tools now, certainly text related tools, work, is they quote their sources. I mean, some of them actually say skip the links. The whole thing is about taking the information from those pages. And now, if I were to see the results of that, I might think, well, AI always gets stuff wrong, so I don't really believe it. So what does the tool do? It gives you the sources. It gives you the trademarks. So that's the way it reassures you that the text that's on that page is worth reading. It's worth listening to because look, it's come from OUP. It's come from wherever. So I think that is for publishers and for the producers of high quality content that gets used by AI tools. There's still something there, because ultimately consumers don't trust AI to get things right, but they do trust reputable publishers. And the only way for the AI tools to get that sort of level of authority is by quoting the sources. So I do think there is some interesting ground left to go on this, and I don't think that the Getty case is it's certainly not the end of the road, but it's also I think we may look back at it in a few years and think, okay, fine, well, that wasn't quite the right case for it, but there will be others that will be. Sorry, so I just want to mention that. So then, yeah, obviously the issues with who is the inventor, who's actually created the inventive concept behind a patent. Now those are complex issues sometimes, but what's not is that this stuff is valuable. So with trade secrets, there's no requirement that something be authored by a human at all. In fact, a lot of confidential information is certainly not generated by humans. The only question really is that it has some value and it's been kept secret. Now, financial services businesses and sort of particularly investment firms have been using AI for years, at least a decade. I would say probably longer than that, and it's allowed them to look at data to spot patterns, which is classic AI. And we're not talking about AI here. We're not really talking about generative AI. We're just talking about machine learning tools. And for years they've been doing this, and they can spot patterns, and they can take unstructured data, and they can create and spot the patterns in that, and they can create trading strategies, or that's just in the financial services. There's all kinds of industries, weather prediction, all of these different things where just spotting trends and spotting patterns allows real insight and creates things that are then models, or and I don't necessarily mean models as in large language models there. I just mean general models for prediction, and those can be incredibly valuable, and they can be entirely created by AI, and there can be no question, in my view, that those can be protected as trade secrets. in fact, I have sued people based on things that that have been created by AI, and that absolutely it wasn't even an issue that the strategies were created that way. So if we've got protection under trade secret, then it's all about the practical stuff of keeping that secret. And the big risk normally with trade secrets, which is why in England at least, trade secrets is a slightly unusual term, because it has two meanings in the UK. So trade secrets has a meaning in employment law, about the kinds of things that you can't prevent, or that you can prevent an employee from taking to a new employer. But it also has the trade secrets from the Trade Secrets Directive meaning, which allies more with the US and now the EU review, basically confidential information. So the risk there is that employees or bad actors or third parties or whatever you want to call them will leave an organization and take with it information that's been created and that is valuable. And in my view, there's no difference there between something that's been created by AI and something created by human. In practice, however, what gets taken is changing. So it was historically, if you would get employees would typically take things like client lists, and quite often you'll get those sorts of things as well. What you're increasingly, or what I am increasingly seeing, is employees who are very technically minded, may even be developers, are taking the tools that made those confidential information, so that they'll take the way that they structured and built models that have then been used to create those trade secrets and recreate the same stuff again somewhere else. And that ultimately is where you get the problem with trade secrets and patents, and you get the distinction. Obviously, a patent allows you to prevent someone doing the same thing, even if they haven't got the sort of know how to do that through unlawful means. Whereas with trade secrets, you need to show that they've actually taken the confidential information and not things that they've worked out in their own heads. So I think that's where the distinction is. And I think large data sets will certainly be protected by trade secrets, may be protected also by database rights, which again protect an investment, and they don't require human authorship. So there is a lot of IP rights that can subsist in these things, that are things that are produced by AI, and I for one feel very positive about that. It does create some issues though, and I think most sort of sophisticated organizations are well aware of the risk of leakage of data and information out of their systems through AI tools. The old saying that says, if you're not paying for it, you are the product, is as true in AI as it is in anything else. And ensuring that only enterprise tools are being used is critical to make sure that data is not leaking, especially confidential data is not leaking. So the position is pretty good under trade secrets. It's I think, as with anything, I think businesses need to be looking at, and all organizations, including research organizations, need to be looking at what's the right for this thing, and sometimes patents will be the best route to securing a monopoly, and sometimes, as it's always been, it's better to keep it secret and try and hold on to it as a trade secret.
Excellent. Thank you very much. Yes, this is again, lots of open questions for courts, for transactional lawyers, for businesses, and for everyday users. The more now, one of the questions that is becoming for just user standpoint is the training of these machines. Now, once we upload our materials or our data, often we don't know or when we know, our consent can be just extracted without, particularly for those who have a very limited legal understanding, they might not even know what they are consenting to. So again, lots of open questions. And since data are the new gold, certainly trade secret will become more and more and more important as we go forward. So now back to Noam. I would like again to ask your reactions, and also, perhaps, you have already discussed a bit of the copyright litigation, but I think it would be interesting here to go full circle and discuss, anything else that you think is relevant for litigation. We also need to be mindful of time, because we don't, we have to, open to questions. I would like to know if the audience has some questions, so please put them in the chat so they can be brought to the speaker. But otherwise, no, I'm in, very shortly.
Very short.
One of the questions I might have as well is, when we go back full circle to copyright, looking at trademarks, looking at design, looking at trade secret, do we see coming forward overlapping rights type of disputes? We are seeing them in many areas already. So places where we're going to see litigation branching out of just copyright and including in the same lawsuit, perhaps multiple rights, and that creates even more challenges for expertise and for judges and lawyers to navigate this very complex cross-jurisdictional maze in many ways of AI and litigation. So what do you think?
So so very briefly, I think the case that Oliver originally referred to, so Getty Images, is actually a good example as to where when you have a proprietor that essentially sits on a corpus of copyrighted material that may or may not be used for AI training, use trademark law in order to try and protect its copyrighted materials, or to push back against the use of its copyright material. That has to do with, for example, the watermarks that they're using, or they have been using, or they're on those images. Those copyright protected images. But I think in that case, and I'll kind of segue to again, one of the points that Oliver made a couple of minutes ago, and that's the referencing systems. And we start to see that more and more. So for example, we had, I think it was a week ago, the Chicago Tribune filed a lawsuit against Perplexity in the United States, so a new one, but this one has to do specifically with that, with the RAG technology. So that's the retrieval augmented generation. And as Oliver said, and I think we start to see, it's not the lawsuits as much as, so of course also lawsuits like this particular lawsuit, but this is where you have the licensing potential. So leaving the training question aside, if AI developers wish to gain trust, transparency of the user, the need to get, first of all, real-time validation and verification from sources that are out there, and the ability to name those sources. So I just retrieved a piece of information. So I think the Guardian reached a deal. Again, I'm speaking from the top of my head recently in relation to RAG. So you as a publisher come or allow or enable an AI developer, an AI company, to use your sources or your archives, not for training only, but in order to verify in real time in relation to a prompt by a user, and you're getting hopefully that would render your resource more popular, because it's much more trustworthy now when I can refer to OUP, or when I can refer to The Guardian, or I can refer to another source that does enjoy public trust.
Thank you very much. I think we might want to move to some of the questions that we see in the chat. First, I'm going to start with the second, and I'm going to start with Oliver. And the question is, who do you think will be responsible and accountable when AI produce harmful content? So now we have authors, and so this is a question of liability. It's not just a question of the author, maybe a question of the platform. We have seen that already, in some of this. So this is a beyond intellectual property question. So what do you think?
Yeah, the sort of availability of harmful content was something that became a big issue for a lot of these platforms very early on. So they have worked very, very hard to avoid it. So one of the issues in the Getty case was about, they called it not suitable for work content. But there was also a broader category of pornographic and other things, which Getty had said, well, if our watermark appears on something pornographic, that's very harmful. There were stories in 2022, it would have been 23, of ChatGPT giving people advice on how to harm themselves and things like that. And I think that because those are such serious bugs in the systems, that they have been broadly removed. The dials have been tweaked in order to make it very unlikely that actually harmful content will arise, assuming we all agree on what is harmful content. But if the general point about if this stuff does appear on there are, in the UK we have the Online Safety Act, so if it's harmful and could impact children, there can be liability for that. So it becomes quite a jurisdictional issue then. There's no, I don't think, commonality between various different jurisdictions on what would happen. But as I said, I think that those platforms don't generally want there to be harmful content arising. But if it's, and this is the problem that the UK Parliament got itself into, is trying to identify what is harmful. Is it lawful but harmful, and what does that mean? So I think it's a very difficult one, and one that is going to have to be a developing thing over the coming years. Don't know if I've answered that. I've tried to.
Thank you. And Noam, what do you think about the first question? So how can author and inventor prevent the work from being used for training without permission or payment? So this is maybe a question that seems basic, but actually it's the crux. So it's the core of the question that we are still debating, I guess.
I think that in the UK it's very much a moving target, because we are before a change. So at present, anything which is for commercial purposes, so training using content, copyright protected content for commercial purposes in the UK, it could lead to copyright liability. Of course, unless it is, as the case was in Getty, when you show or when you establish that the training took place outside of the UK, then of course your ability as a content provider, or as a copyright holder, is much more limited. In Europe, I mean, that's a question that probably, in Europe, in the EU, that's a question that we probably don't have enough time to go into. I mean, we do have this, what appears to be extraterritorial reach of the AI Act. For myself, I'm not convinced that that's exactly the effect that it will have. I think it's fraught with difficulties. But in the EU, I guess the first advice would be for a content provider or a copyright holder is to reserve your rights, and to reserve your rights in order to be on the safe side in a machine readable format, so something like the robot TXT protocol, rather than through contractual terms, because the ability of crawlers to understand contractual terms is not really there, and whether this is appropriate means, this would be considered reservation as appropriate means to reserve your right is yet to be seen. So a machine readable format, and for example, if you're a publisher, you can use your you can use Onyx. I guess anyone who is a publisher out there would know what or works in the publishing industry would know what Onyx means. You can use Onyx as part of the metadata that you embed within your web pages. So that would be my advice. Reserve your right as much as you can. Use machine readable formats, and that should give you some coverage, and definitely perhaps an incentive for AI developers to come to you and negotiate a licensing arrangement.
Thank you. I don't know if there are more questions that we could address. Our time is up, but allow me to thank the speakers. And this is just a drop in the bucket of a very important and ongoing discussion, but certainly was hopefully useful for our audience. And again, thank you to OUP for organizing and putting together this really fabulous panel.
And I want to say a huge thank you to our speakers as well for a great discussion, and to you, Professor Calboli, for being our panel chair. We don't have any questions for now, but thank you very much for attending, for joining us today. Actually, we do seem to have one question that has just been posted.
Thanks a lot for an insightful question. My question concerns protecting human creativity and innovation rather than technical invention. How should IP deal with creative and innovative value that falls within copyright? Yet, it's increasingly, AI, its challenges because of the pace and because of the, simply the often impossibility to know what's been. And here's, this is just my question also to the panels. It's based, building up on this question is IP the answer, or like in the digital technologies, is actually digital right management the answer? It's technical barriers that have been created, in the late 90s, early 2000s, starting with the Digital Millennium Act and then the various international treaties. We have seen the needle moving from copyright enforcement to digital right management, and a lot of technical measure as probably the only very effective way to prevent infringing and and piracy. I mean, maybe not as effective, but certainly more effective than running it to courts. And so here the question is IP the answer? We are discussing this in the IP world, but it's just maybe something that we will see more and more, the creation maybe of new technology to prevent misappropriation of author works. What do you think in terms of, I personally think technology will be a much more effective response. It is already becoming a more effective response. How then we can have, and certainly the AI as we know it, it's not able to train on the same materials that are, copyrighted or that are under wall with the same ease that he had, maybe a few years ago. Now everybody's much more scrupulous about their content. So what do you think? IP, technology, free, fair use. Again,
I think rights holders are going to have to use every tool they have. And so sometimes it will be IP. I don't think the problem here really is with IP law. I think the problem is jurisdictional, and that in the US it seems like fair use seems to be running as an answer in a way that it wouldn't in the UK, and the result of that is that no one is training these models in the UK. So you just end up with a race to the bottom of where the law will permit the thing. I mean, but ultimately, LLMs and AI tools, they're going to become like electricity. You won't necessarily care who's created it. It's going to be very fungible in the sort of sense that you'll be able to swap from one to another. You know, in the last month, you've seen sort of lots of people say Gemini is better than, you know, OpenAI than GPT now. So you just get people moving around. My view of it is, if you take a longer view, the days of the open internet for publishing content are probably coming to an end. You know, if I were a news publisher, I would be quite concerned about my content just feeding into AI tools now that compete with me and don't pay me. So if I'm a UK publisher, I think, okay, I either sue these people in the US and they'll give me some pitiful license to pay me for the work that I've done, or I just go to my own consumers and I find my own route to them, and I don't publish everything on the open internet. And if they want to if the AI companies want to try and get into my walled garden, good luck to them. You know, because there'll be ways of preventing it. So I think publishers in particular, who are the ones that are most affected by this, will just have to find technical means of stopping AI tools from harvesting their content, and they'll have to find other ways to make sure that consumers find their stuff, read them, and want to pay them. So that's my view of it.
Noam.
There are, so for example, I mentioned the Chicago Tribune lawsuits. One of the allegations there was that Perplexity's crawlers are sophisticated enough so that they managed to go behind Tribune's paywall and actually access content that was sitting there. Whether or not that would be proven in court, that is yet to be seen. So, you know, to an extent, when there's a will, there's a way, right? If you're an AI developer, but I think that, and I'm going back again to Getty. If we, as Oliver explained, the argument that a model as trained contains copies of the works that were used to train it, where you are able to work backwards from the model. So if you subject the model to a data extraction exercise, you manage to go back to the original. That, to an extent, could help in a way, could help publishers to bridge the jurisdictional issue, because in that case, no matter where you actually train your model, train it in the States by all means, right? Is the model available in the United Kingdom? Can I actually access the model and go back to the original? In that case, then I have a copy in the I have a copy in the model that is available in the United Kingdom, potentially, right? And under such circumstances, even if you take everything and you train in Japan, which is very friendly for that purpose, as we know, so very liberal regime in terms of training on the basis of copyright protected material. If the view that a model may contain infringing copies in the weights, embedded in the weights and the tokens, that can help to some extent. But I completely agree with Oliver. I think it's a joint exercise of both the law working in tandem with technology in order to try and bring. In the end of the day, it's about bringing AI companies to the table in order to negotiate a licensing agreement. I think as we sat today and we prepared and we started our this podcast just earlier, just a couple of hours earlier, we had this piece of news that Disney reached an arrangement and invest, well, at the value of $1 billion US, where they are prepared to, so they make an investment in OpenAI, and they are under some kind of an arrangement, making their characters available to use by that model. So the idea is to bring them to the table, because I remember I looked at some data according to which, under some predictions, by 2030, publishers could generate or derive up to 30% of their income from AI tools that are available out there. So from licensing. So it's a, again, I'm going back to it. You know, we do live in interesting times where things are changing quite quickly.
Well, it looks like we don't have any more questions, Professor Calboli, but I just wanted to say again a huge thank you to the three of you for this discussion, and thank you to you all in the audience for joining us today, and I hope you enjoyed this as much as I did. You've got a few thank you in the chat and also requests for more discussion, so maybe we'll be organizing more soon in the future. Thanks everyone, and well, have a good morning, a good afternoon, a good evening, wherever you are. And we are unfortunately out of time now, so I just wanted to say a goodbye.
Goodbye.
Thank you.